before the inquiry which the Honorable Chairman appointed was completely at variance. The truth was something else. I'll refer to 3 illustrations of this truth, of this fact. The Honorable Judge says the committee that the Honorable Chairman appointed mentioned that the judge was a holder of a particular account, whereas the account belonged to some other Sumitra Sen, and he's being hanged because he held an account. The committee attributed a bank account to him which is in the name of some other Sumitra Sen. When all of us heard this, we were actually surprised that how the committee could commit such a patent error on the face of it. I checked up the entire evidence. When the charge was made against him that you obtained monies by sale of goods in the Steel Authority case, you usurped those monies. You misappropriated those monies. On the contrary, from some other case of Calcutta fans where you were a special officer, you invested those monies in a company called Links India. The committee or any other litigant did not make this charge of this account against him. This judge, in the first instance through his mother, went to a single judge of the Calcutta High Court. And he told the single judge of the Calcutta High Court, well, I had kept this money in account number 01 SLP 0156800. And this money was invested in Links India. Through his mother, he filed a written note. This account number that he himself gave was the account of the other Sumitra Sen. So he himself in a written note, and that written note, I hold it in my hand, the relevant extract, is before the inquiry committee. The Calcutta High Court never had an opportunity to see it. Even the in-house inquiry did not get it. It's only the inquiry appointed by the chairman that they obtained this by directing the bank to come here. And then they asked the bank, not only this, he went then, and when he challenged the order of the division bench, at 2 places, and I'll read it, and those familiar with court proceedings will appreciate that this is in form of a grounds of appeal and an interim application. He makes the same observation. For the learned judge failed to appreciate that all investments made by the erstwhile receiver in the company were by way of checks drawn on ANZ Grindlay Bank from bank account number 01 SLP 0156800. His defense was that from this account I made the investments into Links. So both the High Court and everybody called for this account, and they found that from this account no investments had been made. Twice he told the division bench this. After he told the division bench this, and the single judge did not accept his case, they found that this account, no monies had been paid to Links. So the matter came up before the inquiry under the Judges Inquiry Act. They charged him not for holding this account, but you say that you, from this account, you paid monies to Links. Unfortunately, from this account, no money has been paid. The copy of the charge is then given to him. He doesn't correct the error. The charge is then given to him. The charge doesn't say that you hold this account. The charge says from this account also no monies has been paid to Links, so your defense is false. When he comes up before the inquiry, he files a detailed reply. Even in the reply, he doesn't say that this belongs to some other Sumitra Sen. It's only when the bank official comes, his counsel now very conveniently puts a question to him. Well, this account doesn't belong to my client, it belongs to somebody else. So the bank rightly says, yes, it belongs to somebody else. So the inquiry committee says, you yourself put up a false account from which you had made the payments. And when it is found out that this is not the real account, so they get the account opening form. The account opening form is of one Sumitra Sen, who is an employee of Food Specialities Limited. So you passed off his account as your account in the pleadings. So the inquiry committee holds against him, from these monies of sale or this account, you have not paid any money. Now what does he do when he appears before us? He comes here and says, look, so casual and vindictive was this inquiry committee that they foisted a false account on me. Sorry, the truth is otherwise. You passed off a false account as your account. When the bank was called, they detected this fraud and the committee has therefore given a finding against you. So the first point on which he tried literally to rubbish the procedure of the inquiry by saying that a false account is foisted on me. The second fact, and we can check up the record, he says, the accounts were materially operated between 1993 and 1995. No bank statements are available. And I have been hanged without the bank statement showing expenditure. This worried me a little, sir. So I went and checked back the record at night. And from the evidence which the committee appointed by the Honorable Chairman, I found, before the High Court, he never brought the bank statement. Obviously, he himself had to show the bank statement of expenditure. But the inquiry appointed by the chairman directed one of the banks to come and show the statement. So the bank filed a ledger. So second falsehood where he misleads the House yesterday is bank statements are not available. The bank statements are available. They are exhibited in the inquiry appointed by the chairperson. What does the bank statement say? I'm just holding the statement of Allahabad Bank, where I had mentioned yesterday some 4,68,000 rupees is deposited. From 24th March 93 onwards, by cash and mostly by cash, some payments by check, he withdraws the money, and 4,68,000 on 8th March 1996, within 2 years, becomes 5,378. No money given to any workman, no money given to Links India, all cash and check withdrawals for himself. Till date, he has not explained what did he do with this money. It's only in 2006, 10 years later, when he got caught, he says, okay, I'll pay with interest. So this House is again misled yesterday by saying bank statements are not here, bank statements are available, I hold them in my hand. The third thing he said yesterday when he tried to mislead us, even if you hold me guilty and remove me, I will still shout from rooftops that I did not misappropriate the money. Well, you may have a determination or a pathological conviction that you have not misused the money, but the best proof is, how were the checks cut out from this account? The checks can't lie. Individuals can. On the inquiry appointed by the Honorable Chairman, what do the checks show? I am holding Xerox copies of the checks, which are on the record of the inquiry. The same names I mentioned yesterday. Checks in favor of one K.L. Yadav, one Guru Enterprises, one Subroto Mukherjee, Brishet Prasad Chaudhary, K.L. Yadav, and the same names which I had mentioned yesterday. Ramnath Roy. Now, who are these people? These are not workmen. What is the second set of checks? The second set of checks is, these are all checks. The record, sir, is with me. It's in your committee's record. Any member can borrow the record from me. All these checks are cut out self and cash withdrawn. You can shout from rooftops you did not withdraw this money. But these checks and this misappropriation will hang like an albatross around your neck, even when you are shouting from rooftops. These are all self-withdrawals. These are all withdrawals in favor of a company, SC Sarkar and Company, the bookseller, publishers that I mentioned. And then there are checks towards ANZ Grindlays Bank card number so-and-so, which is for Visa credit card. Exactly the same facts I had given yesterday. Now you use the money, you utilize the money, which is really custodia legis, as he says, in his possession, which is case property. He holds it as a trustee. And when he holds it as a trustee, he not only misuses this money, misappropriates this money, but in 2003, when he becomes a judge, he doesn't tell the court that I should now be discharged. He continues this misappropriation. The misappropriation continues till 2006. And the second limb of his offense is when he is called before courts, when he is called before an in-house inquiry, when he is called before the inquiry appointed by the chairman, he tells them, I made some wrongful investments, there must have been an error of judgment on my part, but there is no misappropriation. Now, self-checks, credit card checks, book publishers' checks, checks in favor of some other unknown gentleman, and both the inquiries, the inquiry appointed by the Chief Justice of India, the inquiry appointed by the chairperson of the Rajyasabha, both inquiries have come to a finding that this was a case of misappropriation. That I eventually went and returned the money. I'm sure that some of us familiar with this branch, and I mentioned this yesterday, the first explanation to breach of trust is, in fact, that's the only explanation, that when you hold money as a trustee to be used for a particular purpose, it's section 403 of the IPC. The explanation is a dishonest misappropriation for time only is a misappropriation in the eyes of law. This section. So any kind of misappropriation, even if it is for a temporary period, in this case the period stretches to almost more than 10 years, is a misappropriation. And as a judge between 2003-2006, he not only continues the misappropriation, he misrepresents to every authority, and he tells every authority which is constituted, well, these were some honest bona fide investments which got lost, and therefore I paid back after 10 years with interest. Can we afford to have judges whose conduct is of this manner? The pleas that he raises are, since that main suit is still pending, this issue is sub judice. The issue of Justice Sen's misconduct or proven misbehavior within the meaning of Article 124 and Article 217 is not pending in any court. In fact, that's the sole jurisdiction of this House. He then says, I did not claim a right of silence. The summons issued to him under the Judges Inquiry Act are, you can appear in person or through counsel, but be prepared to answer all questions. So his counsel appears, and it's a clever strategy. He doesn't appear himself, nor offer himself as a witness. He is the best available person who can tell us and produce his accounts. What would a judge do? He'll be candid and say, this is how I spent the money. It was an error of judgment. I compensate the lost cost. He doesn't appear because these checks would be confronted with him. The accounts would be confronted to him, and he'll have no answers to give. So the second limb of the charge on which he is held guilty is his misconduct during his tenure as a judge, both continuing the misappropriation and stating incorrect, inaccurate facts. So on each of these grounds, when two different bodies have come to a conclusion, and in all fairness, we are not really bound by what the in-house inquiry has said. We are not even bound by what the Chief Justice of India's, the then Chief Justice's letter to the Prime Minister is. There may be many cases of a grosser impropriety of which evidence unfortunately may not be forthcoming. Therefore, we have to consider how we strengthen the system that even those cases do not go unchecked. But is that a ground that many people who have committed similar or larger offenses have got away, therefore why pick me up? Why single me? Can we afford to have a judge whose conduct smacks of this kind of a proven misconduct? And therefore, when an opportunity has come where a committee of two very eminent judges and one very eminent jurist has come to a finding, is there anything extraordinary in his presentation that they have violated the procedures or the substantive facts they are incorrect, that we should really consider not accepting the committee? And therefore, sir, I concluded yesterday, and I'm reaffirming that, I therefore support Mr. Sitaram Yechury's motion that this is a fit case of proven misconduct where the judge concerned must be removed from office, and the address to the President should be so recommended by this Honourable House. So just a few observations. The first thing that comes to our mind, and this has nothing to do with this particular case, that even in 2003, this misconduct was continuing. How come such persons get to be appointed? It really seriously means that we have to revisit that process. Originally, when the Constitution was framed, we had a system where judges are appointed by the executive government in consultation with the Chief Justice of India. Ordinarily, the government would be bound by the Chief Justice's advice. In 1993, that system got changed by a judicial interpretation, and the advice of the Chief Justice of India was binding on the executive government. That's the position today. Today, effectively, even though the government is a part of the consultation process, it can refer back the case once. But effectively, our experience has been, this was the experience when the NDA government was in power, it's the experience of the present government, that we are living in a system where judges appoint judges. The government at best has only a very marginal say. There is no other process by which there is any kind of a participation in the process of appointment of judges. So both the pre-93 system and the post-1993 system had several handicaps. The best in this country are not willing to become judges. We have to seriously consider why. At times, the selection process, when only judges appoint judges, and the process is a non-transparent process, will always create situations where rumors in the corridors of the court and those who are close observers of the judicial process will be far too many. It was unthinkable once upon a time, it is not unthinkable today. And that is why, whereas on one hand I suggested that vigilance has to increase, at the same time we think of an alternative. And my suggestion to the alternative is, I'm not going into details, but a twofold alternative. We should seriously consider a system which is being debated about setting up a National Judicial Commission. The National Judicial Commission must have judges. It must have the participation of the executive. It can also have participation selected by a collegium of some eminent citizens. It can't only remain the domain of the judges. And therefore, public interest has to be protected in the matter of appointment of competent judges, in the matter of appointment of judges who are men of integrity, men of scholarship. Not only this, the criteria for appointment today doesn't exist. It's today the discretion of the collegium. Collegium is also a system of sharing the spoils. When the high courts recommend, members of the collegium share the spoils. This is an impression which close observers have. And therefore, the discretion of whether the collegium system continues or we have a National Judicial Commission must also be now statutorily regulated so that arbitrariness can be avoided. After all, there has to be some objective criteria. There is no, except elected offices, there is no other appointment which is made where there is no threshold criteria for entry. What is your academic qualification? How bright were you during your academic days? What's your experience, number of years as a lawyer? If you are a judge, how many judgments have you written? How many have been set aside? How many have been upheld? How many juniors have you trained? How many cases have you argued? How many cases have been reported which you have argued? Have you got laws laid down? Have you written papers on legal subjects? These are all objective criteria. Now, one cannot disregard them and say, I pick a name out of the hat and appoint him because I'm in the collegium. And therefore, we need, I'm glad the Honorable Prime Minister is himself here, we need a system where this should be seriously reviewed. Secondly, sir, the matter of judges judging judges and nobody else participating in this is also an issue which requires a serious review and which requires to be referred to, in my opinion, the same National Judicial Commission. The third issue, when appointments are made, we have to seriously consider whether the institution functions. It functions without any pressures. So today, whether it is politicized appointments, or it is appointments which lack credibility, or it is subsequent lack of accountability, or biases on account of relatives, biases on account of religion, caste, personal relationships. Now, these are all areas where accountability and vigilance norms have to be improved and increased so that the independence of the institution can seriously be preserved. And I have always believed, sir, that we must seriously consider this larger issue of almost every retiring judge, barring a few honorable exceptions, holding a belief that he is entitled to a job after retirement. Jobs have been provided in certain statutes, they are created by certain judicial orders. And therefore, the search for a job on the eve of retirement begins. As a result of which, there is a serious doubt which is raised that retirement eve judgments at times get influenced by the desire to get a job after retirement. And therefore, I think when there is a bill pending with regard to increasing the retirement age from 62 to 65 in the case of High Court judges, we should correspondingly think of increasing the judge strength, even increasing the facilities and the remunerations available, the pensions available, but putting a stop to this practice of everybody being entitled to a job after retirement, because the desire of a job after retirement is now becoming a serious threat to judicial independence. And therefore, this, and lastly, sir, just a brief comment. I said in the very beginning that the separation of powers is one of the basic features of our Constitution. At times it was argued that the separation of powers is threatened because the governments of the day don't want an independent judiciary. They want to influence the independence of judiciary. So the theories like committed judges, judges with a social philosophy, these were all propounded at one point of time. Those are now ideas of the past. Separation of powers requires that every institution works in its own spheres. And if every institution works in its own spheres, it has to lay down the Lakshman Rekha of its own jurisdiction. But while laying down that Lakshman Rekha of its own jurisdiction, if one steps into the other's domain, and I must candidly confess that this attempt to encroach upon the Lakshman Rekha is neither coming from governments of the day in the center of the states, nor does it come from the executive or the legislature. Some serious sidestepping is coming from the judicial institution itself. And therefore, we require a certain element of judicial statesmanship, we require a certain legislative vision that we can maintain this separation of powers. Otherwise, what should be the economic philosophy of India? What should be our economic policy? Whether we go to the post-91 policy of liberalization or we go to state controls is a matter entirely for the executive. Courts can't say that this is neoliberalism which is creating problems. Courts can't have an ideology. The only ideology courts can have is commitment to the rule of law and what the law is made by Parliament. courts can't tell the government. There was an incident in the past where courts told our security agencies, when a terrorist group was holed up in Kashmir, of how many calories are to be fed to the terrorists. Because they have a right under Article 21 carrying a gun in their own hands. How Maoism is to be fought or insurgency in Northeast is to be formed, we've gone through this debate in this house. That's a domain of the government. The government has to decide the policy. The courts can't decide that policy. What should be the land acquisition policy? The government is seriously contemplating a new Land Acquisition Act. What should be the quantum of relief and rehabilitation? And therefore, these are all areas. I recently came across a fact: a Pakistani prisoner should be released. Now, there may be some space for compassion in any civilized society, but whether the government of India wants to release the Pakistani prisoner or he wants to exchange it for another Indian prisoner in Pakistan is a matter of the foreign policy or the security policy of the government of India. We have not handed over the management of India's foreign policy to the Supreme Court of India. And therefore, how the Pakistani prisoner is to be treated, whether he released or otherwise, is entirely in the domain of the government of India. Now, these are all examples of recent past that I am mentioning, where the space of separation of powers, the line itself gets obliterated, and the encroachment in most cases is neither coming from the legislature nor the executive. And therefore, we need a serious introspection, and I therefore said we need both a judicial vision, a legislative statesmanship, and vice versa in this country, so that the correct balance on the separation of powers can itself be maintained. Finally, sir, we were dealing with the case of a delinquent judge. I am of the clear opinion that going through the reasoning of the appointment committee, of the inquiry committee, detailed reasoning has been given. It's a very well-written report, which is substantiated by a huge number of documents. The conduct of the judge leaves much to be desired. His conduct as a receiver, his conduct as a judge, his conduct in the course of the inquiry, and finally, though not a ground for impeachment, but a ground on basis of which we must make up our own assessment, the kind of statements he made yesterday, I think this is a case which should leave none of us in doubt that it's a fit case for removal of this judge, and we must so make a recommendation of the address to the President of India.